Yes. Yes, okay.
We apologize for the audio problems in the first 15 minutes of our session, but Ira is going to be nice and loud for everyone, especially those who are not attending but listening in right now.
Let's see, I don't know how to do these things. Oh, there we go, okay. Okay. On February 20, 1932, declared national war in Germany. Franco was practicing law in Germany at the time and continued to do so until he had to flee the country in 1938. He wrote this period that was ultimately published in the United States with the help, ironically, of the States, the former president for whom the book is titled The Dual State. It's a little difficult for those interested in the subject. It's philosophical, it's about what happened. It's a very interesting book. Franco tries to explain in this book how under fascism, the courts and the legal system operated on two independent. One is called the normative state, the other is the prerogative state. I bring this to your attention to understand the which now operate, particularly as immigration orders, and with particular reference to the Supreme Court and the things that it was saying, taking people to El Salvador to a prison without any foundation and so forth. In the normative state, the courts function as they always have, deciding cases based upon principles. In the prerogative state, the government, despite being subject to laws, exercises its political authority to engage in political acts that it and its party officials are found to be beyond the jurisdiction of the courts. So he states in the book, quote, it's the complete abolition of the of law as the chief characteristic of the prerogative state. And since the jurisdiction of the prerogative state is not defined, as we can tell by some of the acts that are now happening, all of a sudden they just say, did this not work? How's that? Is that better? Okay. Trump just comes up with different things, like we're going to have martial law in Los Angeles, or we're going to have the Alien Registration Act without publishing it. And so, and since the jurisdiction of the prerogative state, just making these claims, is not legally defined, there's no guarantee of the stability of the normative law. That is, we don't know what's going to happen because we don't follow the normative law when it comes to these absolute determinations. What's going on? Oh, you don't need this? Okay, let's see, can you hear me?
Yeah.
Yes?
Good.
Okay.
That's good.
Franco gives numerous examples in this book, and I'll just give you one illustrative purpose and then turn to our Supreme Court decisions. A Jewish attorney had immigrated in 1933 from Germany after the government removed all licenses for Jews to practice law. He sought to obtain his birth certificate, presumably to establish his birth to the immigration authorities in his new country of emigration. The registrar under German law was absolutely required to provide the birth certificate. And the lower court judge said, yeah, he was entitled to his birth certificate and ruled in the lawyer's favor. The highest German court reversed, saying it was beyond the jurisdiction of the courts because the Gestapo had issued an executive order barring the issuance, and the registrar is bound to follow that order. The court has no authority to review the grounds for the instruction. And as I'll talk about, as you know, under the Alien Enemies Act, the question is ultimately going to be, does the court have the authority to review when the president says something that's patently ridiculous? We're obviously not at war. There is no incursion, but the president has said that. And the question is, will the court review it? So this is not all, theoretical and hypothetical. So this is what they call, and what he calls in the book, flipping the switch. In the normative state, usual legal principles would have required the issuance of the birth certificate, but in the prerogative state, the government intervenes, reversing the law, and the highest court says we have no authority to intervene because the government's decrees are beyond our jurisdiction. It thus makes all political decisions beyond the courts and creates instability within the court system because no one no longer knows actually what the rules of law are. So let's look at what's happening in the Supreme Court. The court is what they call in the court, and what we see happening now is what we call the shadow emergency docket, which I've now renamed the Trump docket since Trump is the only one really going there on an emergency basis. And they've tried to avoid the ultimate concession that would make our legal system no different than Germany by not giving explanations for its decision. So my point is the Supreme Court really can't decide ultimately what the heck they're going to do. And the reason, and so right now, they're really not giving any explanations for what they're doing, if you haven't noticed. So in Noam, let's take Noam versus Svetlana Doe. The district court issues an injunction against Trump's executive order, and the DHS follows up revoking parole to Cuban, Haitian, Nicaraguan, and Venezuelan citizens. You all know this. They've revoked the parole program. The district court, in a detailed 49-page order, relying on the proper legal standard, which for an injunction pending appeal. The Supreme Court says, stays the order, this 49-page order, without any word, okay, without a word of explanation, nothing. They just say, we, the Supreme Court, stay the decision. And, you know, there is a dissent, and the dissent says they botched the assessment. But what's the assessment? We don't even know what assessment was made because they never said anything. And that's an indication of their kind of instability about what the court is actually going to do when faced with these kinds of issues where there are executive orders by a president who they may or may not want to confront. In Norm versus National TPS Alliance, you know, that's the TPS case, taking away TPS from Venezuelans. The district court there entered an 85-page order on granting the plaintiff's claims. The Court of Appeals, following the proper standard under Nikin, you know, the Supreme Court in Nikin has set forth a standard which you can use to get a stay or not. And for those of you who practice, you know, sometimes you get the stay and sometimes you don't. And they always cite Nikin as the standard under which you can get a stay. The Court of Appeals found that under Nikin, a stay was not warranted. The Supreme Court simply grants Trump's stay without citation to Nikin or any explanation. They just granted it. And then there's Trump v. Wilcox, which is even a more interesting case, which has nothing to do with immigration. It's where the president fires a member of the National Labor Relations Board and member of the Merit Systems Protection Board. And the members obtain an injunction in the lower court. In the normative state of the law, it has been clear for 90 years, based on Humphrey's executor's case, that the president absolutely did not have the authority to do it. The majority of the court, without even mentioning Humphrey's executor, grants a stay. And then in Trump versus JGG, the court avoids the obvious legal issue of whether the Alien Enemies Act applies at all and uses a procedural device to avoid ruling on the obvious question by not saying the AEA is illegal in this circumstance, which is, you know, I mean, you have to be kind of deaf, dumb, and blind, you know, to say that the AEA applies. I mean, even very conservative federal judges in Texas have said, of course it doesn't apply. There's no war. There's no incursion. in the United States, and there's certainly no invasion. Those are the three criteria for the AEA, and yet the Supreme Court will not say, or hasn't yet said, that the use of the AEA was impermissible. And this is what I mean in talking about the prerogative state. They could have shut down all of this litigation on day one by simply saying the president didn't have the authority to use the AEA in sending anybody anywhere. They chose not to do that. And instead, and it's so interesting, you know, when we read this stuff in the press, I'm always amused because they're always pictured as these great wins. And the lawyers, by the way, have done incredible work. And this is not to diminish anything they've done. In fact, an immigrants list was giving an award to Lee Gallant, who did the JGG case and is an unbelievable lawyer. But the point is, instead of saying that the AEA is illegal, they determined that the plaintiffs filed the case in the wrong court and that they should have filed a habeas instead. Now, that's an obvious dodge for anybody who follows what the court does. And the same in AARP v. Trump, where they found that not giving sufficient notice to persons under the AEA, again, they could have just said the AEA doesn't apply. But then now they're talking about what quality of notice should be given to people before we send them to, you know, the modern day concentration camp in El Salvador, where we can give them notice of it first, which they, all of us know, are likely to ignore anyway. In AARP, where they found that not giving sufficient notice to persons subject to the Alien Enemies Act may be the court therefore dodged the obvious major issue where the improper use of executive authority may be challenged, therefore conceding the executive order's preeminence to the rule of law. Trump versus JGG and AARP is symptomatic of something that that is well known in the literature regarding the unitary executive. There are 6 members of the United States Supreme Court that believe that Article 2 gives the president have an all-powerful executive who would usher in autocracy, and an all-power executive who was like Trump. So it'll be interesting to see in the coming months whether Trump will pretextually use martial rule, as he indicated, decided for months. And then if you lose that, you appeal. Well, some courts have said, oh, you can't do that because you never appealed the underlying deportation order. And other courts have said, well, why would you appeal the underlying deportation order? There was no issue. The issue was with withholding only. So the withholding only cases, the asylum only, those cases where people want to appeal and the courts try and throw them out saying, well, you never appealed the underlying deportation order itself. That's the same thing that happened actually here in Monsalvo v. Bondi. The way the court did it is, they basically said he had no reason, which is true. The respondent had no reason to seek an appeal of the underlying deportation order because he'd been given voluntary departure. So he never appealed the underlying deportation order. And when his motion to reopen was denied, he appealed the motion to reopen denial. And the court said, yeah, you could say that there was no jurisdiction because he didn't appeal the underlying deportation order, but there was no purpose in appealing the underlying deportation order. He could have just appealed, as he did, the motion to reopen. So that's the issue also that will come up in the Riley case, because that's a case, again, of withholding of removal, the same jurisdictional issue. And I think they're having a difficult time with it, but they'll probably decide, I'd like to think they'll decide that you can appeal separately the withholding of removal, or appeal, in this case, separately the motion to reopen, without having to have made a meaningless appeal of the underlying deportation order. The next one was, how much time we got left?
We have 8 minutes left.
Okay. Oh, we got to. The next one is Lackey v. Stinney, which is not an immigration case. It's a 1983, 1988 case under the Civil Rights Act, but it will clearly have importance for, what we do in filing litigation. The court decided that the entry of a preliminary injunction, where the government then follows the preliminary injunction and the case is dismissed, is not a final order for purposes of getting attorney's fees. That's a big issue if you're a civil rights lawyer, right? You guys know. So the effect, I think, will be extremely harmful. I mean, if you look at the shadow docket, look at all of those cases, the Trump docket, look at all those cases. They're all preliminary injunctions. So the court's saying, if the preliminary injunction's issued and the government obeys the preliminary injunction, the case is over, you don't get attorney's fees. And there's a lot of attorney's fees in doing a preliminary injunction, as these two great lawyers know. It's not, most of the cases, the preliminary injunction. So it's a problem. And I think what's going to happen, as happened in other circumstances, they're probably going to apply this to the Equal Access to Justice Act, so that if you go into court on an immigration case and you seek EJIA fees, they're going to likely say the same thing. They haven't had a case yet, but they may. Okay, the next thing, although it's not on, it's not even on here, I think, is Martin versus the United States. And this is like my new obsession. And I'm going to talk about this at the Immigrants List panel too. I really believe that we as lawyers have an obligation now to start filing federal torts claim actions. And there's lots of political reasons to do that. There's lots of practical reasons. Federal torts claim basically says if a law enforcement officer engages in improperly an assault, battery, false imprisonment, false arrest, abusive process, and malicious prosecution, that you can sue them. They don't have sovereign immunity. And the issue is very, very important, because I think a couple of things are happening at the same time. Stephen Malicious in the White House is, attempting to force ICE officers to bring in 3,000 people a day. I mean, you've all probably heard this. And, there's a lot of ICE officers who don't want to do it. That isn't what they signed up for. They didn't sign up. HSI didn't sign up to go and arrest somebody in a grocery store. The FBI, because they put everybody on it. They put the FBI, they put DEA, they put AFT. All of those people are working on arrests for what you see in the streets of America now. And many of them don't want to do it. And some of them are very frustrated, and they're working 6.5 days a week. And so people make mistakes. And some other people just do it to be, malicious. But most of them, I think, are, pretty responsible people, and they make a lot of mistakes. And when they make those mistakes, you can sue them. And if we sue them enough, just like with the habeas, just like years before with mandamuses, if you start bringing all these federal torts claim actions all over the country, it's got to percolate up to the White House pretty quickly, because then they have to defend all these cases in federal court. They don't even have the resources to defend cases now because half of the Department of Justice is leaving. Anyway, so Martin is in the context of a federal tort claim case. It's an interesting case. It was a homeowner who brought an action because they raided the wrong house. You may have heard, this wasn't the case like the one in Oklahoma, but you may have heard of the Oklahoma case where ICE came in. They went into the house in the middle of the night. They dragged the mother out with the 3 kids in the rain. They took everything in the house. And then the next day they went, oops, we made a mistake. We went to the wrong house. So is that, there's a question as to whether or not that is an action under the Federal Torts Claim Act, or whether or not the government could say it's a discretionary action. In this case, the 11th Circuit had this bizarre, the way the Federal Torts Claim Act works is it says the government has immunity, except for cases involving law enforcement officers. But then in those circumstances that I mentioned, but then it says also that there are all these other grounds to not allow a lawsuit. It's called the discretionary function exception to being able to sue or not. So this case really involved whether or not the 11th Circuit's own made-up rule, which was a rule that said some nexus furthering federal policy, is also an exemption under the Federal Torts Claim Act. They said that's nonsense. They just made that up, which they did. The statute has 13 different categories, but they did say, which is not great, they said in the House case, the discretionary function exception could have applied, and we're sending it back to the lower courts to decide whether or not the discretionary function exception applies. There is a concurrence in the case. I think it was by Justice Sotomayor saying essentially we shouldn't apply the discretionary function in a case like this. It's pretty outrageous that they got the wrong house. That isn't what the Congress meant when they had and used discretionary function. So Martin versus the United States, it's also a good case to read to get you familiar with the Federal Torts Claim Act. And then I think we're almost at the end. I'm not going to talk about Martin's.
We have about 3 minutes left. Do you want to take a couple questions? Do you want to take a couple of questions?
Also, real quick,
Sure.
on the Federal Tort Claims Act, we added 2 slides late in the game, and they are in the slides, but they aren't in the packet that you have now. Check your AILA.org basket, and over the next week, the updated versions of everything will come through, and there will be 2 more slides in this slide.
So we have a couple questions for Ira here. One is, with the shadow docket, is it possible for the government to appeal directly from the district court, or do they have to still go through the circuit courts first?
That's a good question. I don't know. You may know. I mean, you 2 may know the answer. I'm not sure. They're supposed to seek a stay technically in the Court of Appeals first, and then go if the Court of Appeals doesn't answer fast enough, which is what I think happened in the AARP case. Well, no, actually they did answer quickly. They answer within 24 hours, then they can seek a stay in the Supreme Court. So, yeah, I think it's that progression, but it all becomes, the real issue here is, and this is why the number of justices complain about it. There's no briefing, there's no briefing in the way, and there's no real oral argument in the way that you would normally do it and take your time and do it the right way. It's just all stay litigation, very quickly done and very quickly presented.
Well, yeah, because what we saw in this Florida case on the criminalization of basically being in Florida, Uthmeyer, the Attorney General, he took it it hadn't been heard at all. But I mean, it was basically like they filed the appeal in the 11th Circuit and he went up to the SCOTUS. Just he didn't wait. But I don't know that he's an appellate expert.
Interesting.
I think that's all of our time. We're going to get the CILA code, and we apologize for the audio issues for the remote attendees. We've done our best today, and hopefully the recording will be available with all of the audio. So we appreciate your patience and your tolerance. And we're going to now hear from our day coordinator with the outgoing message and our CILA code.
Thank you so much, Brian, and thank you all for attending this session.